Hey everybody, welcome to episode 5050 of Estate Planning TV. I'm your host, Christopher Small. I'm the owner of CMS Law Firm, and this is the internet's most passionate show about estate planning. Welcome. It is one day before the 4th of July, and I'm excited to be here with you today talking about some fun stuff, some interesting stuff. I don't know if this is fun, I guess, but it's a topic that I think a lot of people deal with and a lot of people think about. And so I wanted to sort of give a quick and dirty overview of how to handle this problem or this situation, or just this scenario in case it arises in your life. I got an email from a faithful podcast listener, is how he described himself the other day. And he asked a question that, I think a lot of people are considering or think about at some point in time. And the situation is this. He's married, happily married, I'm assuming, and he's got a revocable living trust that's set up for his family. He and his wife are co-trustees of the trust, I'm assuming. And the way that these trusts usually work is when the first spouse passes away, the second spouse just remains on as the trustee of the trust and the beneficiary of the trust. And then when that surviving spouse dies, then the next trustee steps in, typically for the benefit of their kids after that. These trusts are often set up when the kids are young to make sure that the money is cared for and overseen and managed, just in case something happens and the parents die young and the kids don't get a big check when they turn 18, which is something that can happen if you don't have a trust. But as time goes by, other things other problems or situations can arise. And the question that this gentleman asked me was whether or not, or if his children are exposed in the scenario I just described, if he dies first, and then the wife or the surviving spouse either remarries or decides to spend all the money or decides to give it to someone else or decides to do whatever they want with the money. And what he wanted to know is, under his current scenario, under just a typical, straightforward, vanilla, revocable living trust, if there was any way or if there was any obligation for the surviving spouse to protect or save or hold on to some of the money for the kids. A typical thing that happens in this scenario can be the surviving spouse remarries and decides that they want to give everything to the surviving spouse, not thinking that the kids are basically going to be cut out, or thinking the kids are going to be cut out and just not caring about it. Another scenario that can happen is a spouse remarries, they have more kids, and then things get complicated. Another scenario where this comes up is when you have a blended family, right? You have two people that are married, they each have kids from a previous relationship, and they want to make sure that everyone is taken care of. So, unfortunately, in this scenario, this person's problems are real. If he dies first, or even if his spouse dies first, and the surviving spouse will have 100% control, 100% authority to revoke the trust or use the trust assets or reassign the trust assets to other people, rewrite the trust, do whatever they want. That is sort of the beauty and the curse of the revocable living trust. It is revocable. It is 100% changeable. And there is no true protection for the secondary beneficiaries when a surviving spouse or when a first spouse passes away. However, it does not mean that all is lost. There is a solution to this problem. It is a relatively simple solution. It will still provide, I think, for everyone in every scenario, but it will provide also some protection from this problem from occurring, which does happen, by the way. I've seen it happen all the time. People, as they get older, what can often happen is people just, as they get older, they lose the ability to reason well. They lose the ability to make good decisions. And when that happens, if there are some unscrupulous people in their life, all sorts of different wrong, bad things can happen. I've seen that scenario happen a bunch of times. I've also seen, quite frankly, where spouses over time, they grow apart, their values and goals change, and they do some sneaky stuff, right? A perfect example of this is I had a client some time ago, and who was married. This was a blended family situation, and his spouse passed away first. He was under the understanding that everything was going to be split equally amongst the kids, all of the kids, just 50-50. But that was not what the spouse planned for. She also didn't plan to pass away first. So when she passed away, that was when the surviving spouse found out that she had changed some beneficiary designations. She had changed some other things so that her kids received pretty much all of her assets. And that was very disturbing and disappointing to him, but it's just real life. Okay, this is just the way that things work, and if you want max protection, you have to create max protection. It's the bottom line. So the way to do that is with a revocable living trust. It just has some little extras thrown in to protect from the situation. Essentially, the way it works is the trust is a revocable living trust until the first spouse dies. When the first spouse dies, you have a certain amount of assets that are carved out into a separate trust. This separate trust is often called the decedent's trust. The decedent's trust is made up of the decedent's assets. In Washington State, we're a community property state. Each spouse technically owns half of everything. And so it would be possible to carve out half of the assets and put them in this decedent's trust. Typically, the way the decedent's trust works is that while the surviving spouse is still alive, they can have access to the income that's spun off of that trust, and they can even have access to the assets within the trust if they need them. Oftentimes, and it depends on sort of your trust factor or your relationship or just how certain you want to be of this happening, but oftentimes the surviving spouse is even the trustee of that decedent's trust. The big difference, though, the big caveat, the big, the solution creating mechanism of this trust is that when this decedent's trust is created, the surviving spouse is not allowed or does not have the power to change who those secondary beneficiaries are. The surviving spouse also, if you want to set it up this way, does not have the power to invade the trust principle unless it's actually needed for health, support, maintenance, education, although I don't know if that education would ever come into it. So what that structure does is preserve those assets in the decedent's trust, make them available for the spouse so that they aren't left high and dry, but also ensures that when the surviving spouse dies, whatever's left in this decedent's trust is going to go where the first person to die wanted it to go, i.e. their kids. So that's it. That's the explanation. Now within this structure, you can do a bunch of different things. Like I said, you can really, there's sort of a variance on the amount of power that you can give the surviving spouse. If you want to really, really ensure that the assets in the decedent's trust are handled properly, you can name a trustee that is not the spouse. That might cause some interesting conversations at home, but it can be done. So that's the sort of the solution and the way that the way to work around it. I think it's although it may be a difficult conversation sometimes, I think it is an important conversation to have because it's often not the surviving spouse's fault that things change and bad decisions are made. Like I said, sometimes old age can really affect the way that we make decisions, and it can really have a tremendous impact and outcome on future generations. And the easiest way to protect against that is by creating these trust structures that I just talked about. All right, so if that was interesting to you and you want to learn more, please call me, 206-659-1512. You can also email me, chris@cmslawfirm.com. You can also just schedule a time to talk. If you want to go to my website, cmslawfirm.com, and go to the contact us page or whatever, there's a scheduling page there. Okay? And by the way, we also do probate. So if you need help with probate, call us. Okay? That's all we do. Estate planning, probate. We're super good at it. Clients love us. Take our job seriously. And I'd love to show you what we can do for you. All right, have a great day. Have a great everything.